Good morning.
Good morning, my lady.
Mr. Lyons.
My lords and lady, I appear on behalf of the appellant and defendant. Mr. Mason and I appeared on the detailed assessment below before Deputy Cost Judge Friston and on appeal to Mrs. Justice Hill. Miss Bedford appears in front of you today leading Mr. Mason for this second appeal. Before I start, my lady, could I deal with two housekeeping matters, if you don't mind?
Yes.
The respondent on Monday identified that they included in the original bundle that got to you the unrevised skeleton argument. Can I start with there is no issue with any of this?
There's a cross-reference point, isn't there?
On Monday, the respondent served a skeleton argument.
Yes.
That should have been the skeleton argument they put in the bundle rather than the skeleton argument they did.
Okay.
There is obviously no objection to it. I am just checking that my lords and my lady had that skeleton argument.
It doesn't differ in any
what it does, my lady,
material sense, does it?
And all it does is it adds, it doesn't, save for it responds to the additional grounds 3 and 4. It is in red. If you've got it properly, you will see it in red.
Okay, I may have it.
You'll find it from memory, I think, at page 399. And if you look at 412, if you see that in red, you'll have it.
No, I don't have that, I'm afraid. Do we have any spare copies?
My lady, I don't have any immediately on me. I can arrange for that to be either sent across electronically or...
Could it be sent electronically straight away to my clerk?
Absolutely. With sincerest apologies, we did attempt to try and render
I have it, not in red, because I'm afraid the judicial printing is by and large in black and white. But
So what?
In that case, may I assist perhaps in a different way? So if one goes to page, which I'm hoping is correct on your bundle, 399, what one will see immediately below the heading of the document entitled Respondent's Appeal Replacement Skeleton,
Yes.
there ought to be an italicised 2 lines which start with this skeleton has been amended.
No, I'm afraid I do not have. Okay, and where's, I've just been passed a copy, where is the red lining?
The red lining, my lady, starts from 4112. It goes over the page to 413, and then that ought to conclude it. You ought to see that ground 3 of the amended grounds I've dealt with at 412, and then over the page 413 is where ground 4
Thank you.
is dealt with.
Okay, thank you.
Sincerest apologies.
So, was there another house?
There is, yes, my lady.
Yeah.
My lady probably will anticipate this one more, which is last night your clerk emailed asking for the judgment of the 8th of November.
We can see it.
I've discussed that with Miss Bedford. Hopefully the email got to you that accompanied it. There are 3 judgments on that day.
Yes.
2 of those we both accept, you don't need to be troubled with. That is the judgment. Sincere apologies. It was referenced in my skeleton argument as well, and obviously referenced in the in Mrs. Justice Hill's
Exactly.
argument.
Yeah.
But hopefully you have that with you now. And I will come on and help you with that and where that fits in with the transcript and where that judgment was delivered in due course, if my lady laws permit me.
Yes.
So, my lady, can I help you with that point straight away, please?
Sorry, but I was going to say before before it was pointed out that I hadn't actually seen the most recent skeleton. that subject to that point, we have all read widely. You don't need to spend a lot of time or real time on introductions. So we've read widely, including all the relevant judgments, hopefully now. This was originally listed for half a day, or a time, the original time estimate from the judge who granted permission was half a day. I see it's been extended to a whole day, but we were rather hoping it need not take up the entire day.
Well, my lady, from my point of view, you'll have your own judgment at the end of this, but I will hopefully not repeat points on what is accepted as a narrow appeal. Not the most complicated appeal, maybe happily or unhappily, that my lords and lady have dealt with. I will hopefully be. We put in you would have noticed in my skeleton argument that I said could be dealt with in half a day.
Yes.
I will try to keep to that timetable. I will outline some facts as well, if you don't mind, and take you through them. But if at any point you say we know that, or I'm not, don't need to be told this, then I will just move on. It was absolutely clear that you read widely from the fact you asked the question of where the 8th of November judgment was.
Yes.
Can I just? You may find it helpful if right now, if we're dealing with the 8th of November judgment, I just give the page reference as to where that appears in the transcript, so you can just orientate yourselves. If you look at page 248, please, of the bundle. And
sorry, I'm just going back to my emails, even though my I do not have the revised skeleton electronically, so if it could be sent to my clerk, that would be very helpful.
My lady, if it assists, I've just been told by those who instructed me that they have in fact just delivered electronically the replacement skeleton to your clerk.
Thank you.
Thank
you. My lady, if my lords and my lady don't mind turning, please, very quickly to page 248 of the bundle. You will see under H, that is part of the transcript where Deputy Cost Judge Foxton gave that judgment, just War and Table. And I'll spend a little bit of time in submissions later on going back to that point, if I may. Subject to your interventions, I'm going to structure my appeal in the following. I'm going to preface, first of all, please, what we say is the central point of this appeal. Secondly, I'm going to set out the background to the appeal. Then I'm going to deal with, significantly, some overarching points about this appeal and why we say the order of Mrs. Justice Hill should be set aside. I will then deal with the individual grounds of appeal. I will be relatively brief on that because you'd have heard a lot about that already. And then I will obviously address the respondent's notice. That is all subject to your intervention.
Thank you.
We submit that the central point of this appeal raises an issue as to when an appellant judge should interfere with a discretionary decision of a judge at first instance. When we say, although I note that it's a contention by the respondent to this appeal, that the individual criticisms of the learned judge were at first instance, the first instance judge were rejected. We say, as Lord Justice Lewison identified in giving us permission, that it is that Mrs. Justice Hill, what she did, and it is very tempting, I accept that, for any appellant judge to do this, and I'll go on to, that you disagree with what the first instance judge did, that discretionary decision, and when you would have and might well have found differently had you been presented with this issue yourself. But yet there is, we say, no sustainable error of law identified in the appeal below. I make this as my underlining submission, that effectively what Mrs. Justice Hill, it's a matter for you obviously, but we submit, that in order to come to the final decision that she made, she found that, and I put this in essence when you read this, doesn't say it expressly, but that Deputy Cost Judge Friston's decision was perverse. Yeah. Overarching this, I make 4 points. I've addressed you about my first point already, the temptation for an appellant judge to substitute a discretionary decision that they disagree with. I will not, for this appeal, and it's not in the authorities bundle, my lords and lady know these authorities probably like the back of your hand, if not better, when Roach, Tanford and Broughton and the test laid out there. Those are all mentioned in Mrs. Justice Hill's judgment. We say that Deputy Cost Judge Friston did not err in principle in his approach, and that Deputy District Judge Cost Friston's exercise of discretion didn't exceed the ambit which reasonable disagreement is possible, adopting the well-known phrases of those cases. My second overarching point is that as judges you'll be well aware of this, that you are dealing with often the trying to find and attempting, the authorities have said this, the least worst solution, balancing diametrically opposed interests of the parties. That discretion, and the courts have said this consistently, is for very good reason that I will not labour unless my lords and lady need to hear from it as to why, is almost exclusively entrusted to the first instance judge. It is the not looking over your shoulder point that I don't need to repeat or outline. My third point is an important point, and it involves a concession. I don't invite your lords and ladies to endorse the appellant's actions, or to state that a judge will also always take the same decision that Deputy Cost Judge Friston took or would have done. If you find in my client's favour, it should not be read as an endorsement by any cost practitioner that the same, in another case, the same result will automatically happen, and I readily concede that. The reason why I readily concede that is that this is by very nature a discretionary decision. The fourth point will hopefully not be lost on you, but we say it is, with all due courtesy and respect to the respondents' very able team, is more lost with them. But this is a second appeal. And you will know that the primary focus as a second appeal is on the first instance decision of the first instance judge.
Absolutely, yes. So the focus, well, it does depend on the second appeal.
Yes.
But I think, from speaking for myself, I would need persuading that the starting point at least shouldn't be anything other than, was the deputy judge, the first instance, entitled to reach the decision that he did?
My lady, I adopt that approach. Can I give you one reference from, again, Lord Justice Lewison in a case of Kyan, Surrey and Barnet? That he said a paragraph too.
So do we have that in?
You don't have it, my lady. It's a short point.
Can you give us the reference then, please?
Would you mind bearing with me for one moment? The reference, the new citation number is 2018 EWCA CIV 451.
451, and the case is?
It's called Kai Surrey it's best known as Kayseri and Barnet. I can give you the full case because there's a lot of parties, but if my lady wants me to email the clerk.
Okay, so 2018 451.
It is,
Thank
yes,
you.
my lady. And can I just read one paragraph?
Which is paragraph?
Paragraph 2.
Thank you.
Which is just Lord Justice Lewison saying, since all the appeals are second appeals, our primary focus must be on the decisions at first instance.
Yes.
That's just, it's an approach that my lords and lady will be, in my respect, submission, very well aware.
Yes.
Those are my 4 overarching points. And can I now come on to the background to the appeal? That I'm going to, as I run through the background, I will take you through passages. It is not going to be exhaustive, my lady, because it is clearly set out by Mrs. Justice.
Yes, and as I said, we have read
in her
carefully,
judgment,
so you could take this quite fast, I think.
My lord and lady will know that this matter came to a detailed assessment on the 5th and 6th of August. What is important, as my lord and ladies have picked up, is that we do not have the transcript at all of the first day of the detailed assessment.
And we don't have a lot of the second day.
We don't have a lot of the second day. What we have is it starts with my arguments that I raised on the issue of the annotated schedule.
Yeah.
It must stand that, and let me be perfectly clear, what I was able to do in the appeal below was recreate through the transcript of what had happened and whether Mr. Mason did or did not raise arguments below. But I don't want to be saying, for the purpose of this appeal, nor that you treat this with circumspect, that I can remember distinctly what happened on the first day.
And you're not giving evidence.
I'm not giving evidence, and I will not be able to assist you, and I believe that would be...
I did read somewhere that this point, the point, we'll call it point 23,
Yes.
was not arrived at until, I think I saw the expression later on the 6th, after other issues were dealt with. I may have picked that up from
my lady,
Mrs. Justice Hill's judgment, but I'm not sure.
Sorry for interrupting, my lady. My lady might well be right about that. Mr. Mason's submissions are all lost on all of this. You will remember, I'm sorry I'm transposing, but as an issue, that I know Chris and Mr. Mason, nothing malifides has happened here, but there was a debate before Mrs. Justice Hill about whether or not if I can call it the Barton arguments, you'd be well aware of, were raised below at all or not. Which Mr. Mason believed they were. I, on behalf of the respondent in that appeal, submitted they weren't by a careful analysis, and Mrs. Justice Hill accepted that. Unhappily, we have, say for an intervention that Mr. Mason makes in my arguments on day 2, we have nothing recording Mr. Mason's arguments on day 2. Going on that, and what I'll say to my lords and lady, this underlines this point about the need to trust that first instance judges. It really puts it into its own prism as to why, given we are missing those transcripts. Can I just give you some page references? You will see, you don't need to turn to them, but at page 353, the arguments in the transcript on the 6th of August are there, my arguments, half of it, I believe. Although I'm going to repeat what I make it very clear that I have no recollection besides relying on that transcript. Unfortunately, it appears that none of what Mr. Mason's argument is recorded, and probably about half the argument. There is an exchange, my lady. I do apologise if you need the wrong page reference.
Yes,
number.
that's not
160 to 167 should have been the page reference. I apologise.
Yes.
My lady, in order to orientate yourself, 353 is I think the judgment oh no, it's not the judgment, it's the annotated schedule.
Yes.
353 is the annotated schedule. 347 is the points of dispute.
Yes.
I don't know whether my lords and lady have taken a brief time to have a look at that at all.
I certainly have.
I don't intend to say anything more except to premises that I accept that the appellant laid out objections to the annotated schedule.
Yes.
Sorry, laid out objections, said that an annotated schedule would follow in due course.
And it
disputes
didn't
about
until very shortly before. Yes, I think we're all clear about that.
There can be no disputes about that. There was a response to it that you would have read.
Yes.
That took an Ainsworth point, but also said that they were able to make reasonable concessions.
Yes.
At 349.
Yes.
Can I now spend some time? You will see that the judgment of Deputy Cost Judge Friston appears at 153 to 157.
Yes.
Of the bundle, which was an extemporary judgment.
Yes.
The deference being applied to it, all of you know very well, to give into an extemporary judgment. Paragraph 19, can I just summarise a few paragraphs if you don't mind? Paragraph 9, the Deputy Cost Judge recognised that it was not a happy state of affairs. Paragraph 18 found that whether the annotated schedule should be allowed was not an easy point. He acknowledged that the schedule was served unacceptably late. He found on the facts of the case that this was not an ambush. I say in my respectful submission, more understandably so, because although it was served very late, there is nothing, and I'm not labouring the point about the annotated schedule, there can't be anything that could have been said as a particular surprise in my respectful submission that was taken in that annotated schedule. At paragraph 23, the cost judge found a degree of concern that the schedule was served so late. He continued about his reading of the practice direction gave him very wide powers, something which Mrs. Justice Hill accepted, used the words wide powers. As to very wide or wide, we might be dancing on the proverbial judicial pinhead. That he was entitled to impose conditions on the payment of costs. Paragraph 27, he declined to strike out the schedule, said that he would impose cost sanctions. Paragraph 29 said that there would be an adjournment to the case. That was to achieve fairness to both parties. And my lady will know what happened on the 8th of November. A further detailed assessment took place. Respondent fails to beat the offer. And the respondent then appealed the decision of Deputy Cost Judge Friston. They obtained a transcript of his decision, not shared with us at all, and that can be found in the transcript for the day that my lady will have read and my lord will have read. Permission to appeal not asked of the judge at any point. The judgment that you see on the 8th of November wasn't, the costs order was not appealed. While I intended to take this later on in my submission, but perhaps it's better right now if I could be permitted. At page 246 of the bundle.
Yes.
There is an exchange where Judge Friston says to Mr. Mason, he says, but it is not the reality that we did lose court time. There is no doubt about that. But it is not the reality that we just lost the tail end of the last hearing because we'd have tipped over to another day in any event, would we not? and then the response, not from me, from Mr. Mason is,
Yes.
but then to follow through its logical conclusion, if the defendant had filed their annotated schedule with the points of dispute, we would have requested a detailed assessment. What he says is
We
they would have
requested a 3-day.
They were requested 3 days, but he doesn't dispute in the transcript that it wouldn't have tipped over into a 3rd day. The problem with this issue is that, and central to the points of the appeal that I make, is that what Mrs. Justice Hill was trying to do was she was trying to replicate the feel that the first instance judge had for it. And it gets worse, missing parts of the transcript on all of this. Now, just to be absolutely fair with all of this, what I do accept is, because it may be a question I'm asked, what was left to deal with? Because it's an obvious question. We did leave the annotated schedule was left to deal with, proportionality was left to deal with, and costs of the assessment were left to deal with. So there would have been time spent recalculating. I am not going to presume, my lords and lady, no. If you want me to explain this process, I will do. Would that be helpful at all? You may, sitting in other cost cases, you may be very well aware of this.
Maybe briefly.
Briefly, well, detailed assessment where you have a bill.
Yes.
That's over
Yes.
half a million
Yes.
pounds. You have the decisions of the judge. The parties then have to go out and recalculate it and agree the calculation. Sometimes that can take a while. Sometimes it can be very quick, depending on the reductions and the nature of the bill. Then after that, as you will know, in the Lowndes two-stage test that you'll be very well aware of, that you deal with proportionality tends to do a detailed assessment at the end.
After the recalculation.
Yes.
Thank you.
Sometimes proportionality can be a very quick issue, as it was on the on the 3rd day with me. Although, if I could just help my lords and ladies with a fact you may not know, that Mrs. Justice Hill ordered that matter be remitted back to Deputy Cost Judge Friston to deal with proportionality.
Is that in the order?
It's in a later order.
Did the effect of Mrs. Justice Hill's order mean that the payment in was beaten?
No.
No. Okay. Just trying to work out the financial issues at stake on this appeal.
You can well work out from that it might well, there's a proportionality, can I say absent the proportionality point, that this will mean that if our appeal succeeds, we have beaten the Part 36 offer that we have made. If our appeal fails, then it may be that the respondent to the appeal beats their Part 36 offer.
That makes me understand, Lisa, that the pointed issue is not simply the difference between what was asked and what was allowed on that part, but there may be knock-on issues on interest and in particular costs.
Well, I can see my lord smiling a bit more here, hearing this appeal than he did maybe before, realising that.
Okay, so it may, rather than necessarily will, make the difference to Part 36.
That is exactly right. Because it's going to be remitted back for proportionality.
Okay, so I hadn't picked up that remittance. It's in a later order.
It's in a later order. If you want,
I think for just to put us in a better picture, overall picture, I would, speaking for myself, I'd like to see that further order.
I will send that order, obviously, in conjunction with Miss Bedford. There are other ancillary orders made in that order about costs and costs of the appeal. But I don't intend to address you on what happened with the costs of the appeal below. I'm not sure, unless you want me to.
I don't think so, but I think we want an overall picture. It's helpful to have an overall picture.
Yes. I think I had just addressed you on what was going to happen if we fell on this appeal and remitted back. At the moment as it stands, remitted back proportionality. There's no appeal on that subsequent order that Mrs. Justice Hill made, which I think I alluded to about what I said was the perversity of the appeal in a way that, you know, if the same result could be taken looking at proportionality, it may not with the judge. There is a different test on it.
Okay.
That element of the order, I should point out as a matter of just final housekeeping on it, has been stayed by agreement of the parties pending this appeal.
The remittal.
Yes.
Yes.
You will know at appeal that the respondent to this appeal to Mrs. Justice Hill, challenged the decision of the Deputy Cost Judge on 5 grounds. And you would have read the authority on what Mrs. Justice Hill said with some care,
Yes.
and her judgment. We submit, although it's a matter of contention, that Mrs. Justice Hill rejected the criticisms of on that appeal, what was the respondent, the appellant in this appeal, on individual grounds. She says, and you will see at ground 2, was that the Deputy Cost Judge Bristol was wrong to decide that points of dispute with reference to the document schedule would have enabled a broad brush assessment in any event. And at page 50, paragraphs 80 and 84, sorry if I'm reading this out, she rejected this.
Where does that point fit in? Let's assume you've got a schedule that is not Ainsworth points of defence, or some paragraph in it's not Ainsworth compliant. But you could do a broad brush, but parties who've taken matters to detailed assessment are not obliged, I think, to do a broad brush assessment. I was wondering where that second point ever fitted into the overall argument.
My lord, I'm not sure it did terribly, because the point was, and I accept for the purpose of this appeal, without permission to rely upon the annotated schedule, the bill, the attack on the document schedule fails.
Strikeout and allowing annotated schedule were effectively going to stand and fall together.
Yes. And just with that, what I've been addressed on this, and why I could maybe quite short on my submissions as to the grounds, the overarching point that I make about that is that strikeout is a draconian ground. It's usually the ground of last resort.
Yes. I mean, you do say that strikeout and the reliance on the schedule would stand or fall together. That's not actually quite the way the deputy judge addressed it. Because he specifically deals with them separately, says one is clear and says he finds the other not an easy decision.
I accept that interpretation on that.
And this may be linked to the point my lord's just made, which is you could, even though it's not Ainsworth compliant, adopting a broad brush approach, make something of point 23 without the schedule. Is that the linkage?
Well, for the purpose of this appeal, without prejudice to any further appeal, and any further debate on that point on Ainsworth and the consequences of it that you may hear, because I argued that below. And
Sorry, you argued what?
That it enabled. Mr. Justice Hill found against me.
Okay.
That Ainsworth didn't say he couldn't conduct a broad brush approach.
Yes.
Mrs. Justice Hill has rejected that argument.
Yes.
It's not one of my grounds of appeal that can be fairly put that is wrong. It is not something that I seek to disturb today. That may take a longer hearing than you've permitted that you want to hear from me today. I am not going to go there, but that is without prejudice for you considering maybe for a bigger bill and an argument there as to how that can be exercised.
So, but I'm just trying to make sure I understand your position today.
Yes.
Which is you do accept, as I understand it, that whether to admit the schedule and whether to strike out point 23 should stand or fall together.
I do accept that.
Which is the approach Mrs. Justice Hill took.
Yes.
And isn't the reality judges have to deliver decisions point by point? But I think in fairness to the cost judge, he knew where he was going
Yes.
at the start, one suspects, because he would form an impression on the basis of all the argument you had heard. But then you have to unfold it
Yes.
in stages.
Giving extemporary judgment can always be better expressed. Courts, higher courts, have adopted that my lords and ladies shouldn't take an overly analytical approach to an extemporary judgment. Extemporary judgments, for obvious reasons, are to be encouraged.
Well, the system couldn't function if we
rather to be discouraged. So that is, and I say my respectful submission in our favour, a point that I will be making is a powerful point in this opinion.
Right. Okay. Well, we're clear about your position.
Yes.
So thank you.
Just for the purpose of it isn't. I accept that for the purpose of the appeal, but not.
No, have it. We have it.
Yes. Then I've addressed you as to ground 2. If I could go back, if I don't mind, on losing my thread slightly, ground 1 very briefly, which I didn't address yet. The deputy cost judge failed to give. Ground 1 was about the deputy cost judge failed to give the interpretation of the practice direction. By that I mean 47, paragraph 8.2. You can find that practice direction if you want to at page 15 of the authorities bundle. I'm not sure my lady and lords will find it especially illuminating to the question, but you can look there if you want.
Well, I think we're clear about
Yes.
this.
An Ainsworth.
And it's not in dispute.
No. She rejected what we say at page 49, and I'm sorry if this reads a bit like a shopping list and how I'm addressing it at the moment, but at page 49, paragraph 76 and 77, and then skipping on to page 54, paragraph 1141, she rejected the criticism that we say of this on the individual ground. Ground 3 I can probably skip forward a little bit, with the Barton and Wright Hassel point. In summary, it was found, I can take your reference if you want it, but I don't think you need it, that point was not argued below. I'm going to paraphrase that. Can I stop there and address, if you don't mind, the respondent's notice a bit on that? Because it might be a good time actually to address the respondent's notice. The respondent's notice wants you to now make a judgment of something that wasn't argued at first instance, wasn't argued in front of Mrs. Justice Hill, and wants to talk about that you can look at now a different part of the CPR 17, authorities on that, to seek guidance to the interpretation of Part 47. I'll return back to that, but I just make the fundamental point on this. That is not the point of respondent's notice. Respondent's notice there is not to argue something that was not raised with the first instance judge, was not raised on the appeal judge, and now wants to raise it with you. And I will, though, very briefly at the end of my submissions address that on its merits, obviously, for yourself, in any event. Mrs. Justice Hill dismissed ground 4, which was that the, curiously, about the appeal, which that ground was, Deputy Cost Judge Briston was wrong to permit the respondent to rely upon the annotated schedule. That's the ground. Do you want me to take you to that ground so you can see it, or you're happy just to take my word for it? It's fleshed out there at page of the judgment 54, paragraphs 111 and paragraphs 1143. She dismissed the ground of the appeal. Ground 5 was that the deputy cost judge was wrong in failing to give proper effect to the practice direction to Part 47, paragraph 13.10, and you can find that in page 19 of the authorities bundle. if you want to. I'm not sure my lord and lady will find that terribly illuminating.
Well, again, I think we're familiar.
Yes. So, can I stop you there and take you to look at one of the authorities, please, that Celtic annuls? That is at page 131 of the authorities bundle. Whilst Mrs. Justice Hill recollected that the Deputy Cost Judge appeared in that hearing as one of the advocates, maybe it got passed over that I was one of the advocates in that hearing as well. So I know Celtic pretty intimately. What Celtic was about was the facts of Celtic were that a month beforehand, the paying party served a point of dispute taking a fundamental attack to a retainer, and that was saying that effectively that the indemnity principle they suspected had been breached, and therefore costs should be nil as a result of it. On that occasion, first instance, previously full-time cost judge, but at that stage a deputy cost judge Campbell didn't allow permission to rely upon that point of dispute. The basis of it, if I can paraphrase it, was there would be need for witness evidence. I can find the reference if you want.
Sorry, I didn't hear.
There would need to be witness evidence.
Oh, okay.
Later on, and what is central, I say, is that there is nothing hard and fast. If you look at page 142 of the authorities bundle, please, paragraph 35. That Mrs. Justice Foster said the rules give a wide discretion to the cost judge to decide on all the circumstances of the case, whether it is furtherance of the overriding objective, namely to decide cases justly, that the particular document ought to be received. It cannot be gainsaid that there will be a time when using the words "the master is just too late." It cannot be characterised as perverse or otherwise unlawful for the master to have come to this conclusion. And right back at the beginning, you heard me use the words perverse. And it won't be lost on why I've used the words perverse on this. But what Mrs. Justice Foster is not saying, and shouldn't be taken as saying, is that had Mr. Campbell, had Deputy Cost Judge Campbell allowed the point to be made, that the respondent in that appeal would be able to attack that decision. She is saying that that is a wide discretionary decision entrusted to the first instance judge. Yeah. And that comes on to a later point that was mentioned in the judgment of Mrs. Justice Hill, where she said, well, Mr. Lyons can't refer you to one single authority where another decision has happened. That is because in this, unusually in this appeal, we're responding to an appeal where there is setting aside a discretionary decision of a judge, firstly. But secondly, you wouldn't expect a raft of authorities at every single decision that a cost judge has taken to allow a schedule to be in front of you. My third point is that every case has its own facts. The other difference in Celtic was that there was no foreshadowing of the point that was going to be taken. In here, there was, in my respectful submission, no matter to you, foreshadowing of the point. Also, whilst the point in Celtic was a complex point, this was not a complicated point that was being taken on that schedule. We say that, and I've taken you to parts of the judgment of Mrs. Justice Hill, while she allowed the appeal on the overarching arguments on grounds 1 to 5. What she said in essence, and I say when reading it, that there's a dispute between, it's a matter of your interpretation, between the respondent to this appeal and the appellant, was how central the fact that it was going to slip over to a third day was in Mrs. Justice Hill's decision on all of this. We say on behalf of the appellant that when you read her judgment in particular, please, starting at 454 to 56, it really is the thrust of her reasoning. And she says that effectively that she believes that Cost Judge Friston misremembered by, and I'm paraphrasing her judgment, but hopefully that you will accept this, said that he misremembered on the 8th why the reason was to adjourn on the 6th. 8th of November, 6th of August, I'm talking.
Yeah. Do you mean 54 to 56?
I do.
You may mean 54.
Page 54 is the judgment of Mrs. Justice Hill.
Oh, pages 54.
Yep.
Thank you.
I should say one thing, although I probably indulge your patience a bit too long with how lengthy I've been so far.
Yes.
I can't take you through to tabs. My bundle doesn't have tabs.
Oh, fine. Pages, I thought it was paragraphs.
But it's really, I would just be citing all the paragraphs.
No, fine. We understand your position.
And she said that I say importantly, at page 56, paragraph 129, that the judge, that's Deputy Cost Judge Friston, failed to apply the overriding objective. My response to that is, well, judges should be taken to know the overriding objective and what is there. They do not need to, in an extemporary judgment each and every time, spell out the overriding objective. And then at paragraphs 114, page 54, she identified that Deputy Cost Judge Friston accepted the points of dispute alone was not, I think, the only complaint, but I want to get back to that. So if you have a look, I say significantly, is what she found at 114 and paragraphs 1, 2, 3 and 4 there. But then she goes on to the overarching argument. So I've done a lengthy lay-up to all of that. I covered some of my points already, and I'm now going to be fairly, with your permission, relatively quick on what I've got to say on the rest of it, because I've said it as we've gone along.
So we're now on overarching points?
Yes, we are. Well, no, I've dealt with the overarching points. This is
Well,
points
you
why
did,
the appeal
yes, you dealt with them earlier
Yes.
on. So you now on the individual ground?
I'm dealing with points about generally why this appeal should be allowed,
Yes.
if you don't
Yeah.
permit me to brief, if you don't mind permitting me to. We say that strikeout is a draconian order of a last resort. The court is permitted, as in this case, to, in the exercise of its discretion, to adopt a lesser sanction, if the justice of the case could be met doing so. In our submission, Deputy Cost Judge Foxton applied himself as Bikuzi, where Lord Wolfe said, and you can look at that paragraph 37 of the Authorities Bundle. I'm not going to read the highlighted sections there. You're well aware of those, what that says. We say that Deputy Cost Judge Foxton applied himself in such a way. There was a lesser sanction that could be imposed. And I say further on from that, it will only be a rare and exceptional case that an appeal judge will be entitled, in my submission, to interfere with a decision to impose a lesser sanction. This is not such a case. I say, with respect to the criticisms, the majority of the criticisms that the respondent in this appeal mounted. The decision was not wrong in substance. My lords and ladies will be well aware, not in the Authorities Bundle, but what was said in, and I've referred to already, Biogen and Mediva, that a judgment is always capable of being better expressed. And does my lady want the references for that at all or not?
No,
I can email it if you want.
Yeah.
This is particularly true of, I say in my respectful submission, unreserved judgment. And this is all trite, but I somewhat apologise to the Court of Appeal for raising these trite points. But you will know, be well aware that it's to be presumed that a judge knew how he should perform his function and what matters he should take into account. And that an appellant court, we say, should resist the temptation to subvert the principle that they should not substitute their own discretion for that of the judge by a narrow textual analysis, which is all in Biogen, which enables them to claim that he misdirected himself. And an appellant court, we say, in my submission, unless there's a compelling reason to assume that he's taken all the factors into his consideration. And those are the overarching, well, the central thrust. And I will then deal with my grounds, having got the point, relatively briefly, if you don't mind. We say that he adopted the incorrect test as to whether Deputy Cost, she adopted the incorrect test as to whether Deputy Cost Judge Foxton should be allowed. I've addressed much of that point already. There was too much focus in Mrs. Justice Hill's judgment, in my respectful submission, about whether the annotated schedule should have necessitated an adjournment or not. That is one factor to put in the melting pot, but it is not the only factor. There's nothing in the overriding objective. There's no magical mystery for a judge to say that is the single bright line reason one way or the other. It may be a factor, it may be heavily weighed in a judge on the facts of the case, but it doesn't prevent you from doing it. But I say in my respectful submission, Mrs. Justice Hill on one point says, well, perhaps, not Woolpack, but Miss Lyon's submissions to the judge misled him, not intentionally, to think that the reason for the third day was solely towards the annotated schedule. But logically, that doesn't actually help when you actually distill break that down. Because if that is right, and I say either way we should succeed on this appeal, if that is right, then the Deputy Cost Judge considered the point and had it in his mind. It doesn't need to be expressed in a bright line judgment setting everything for you. Particularly where the respondent in this appeal doesn't even try to help by seeking permission to appeal on the third day. And I made that point in the skeleton argument, obtaining a transcript. And there's a fundamental point here that it may have been forgotten slightly in the lower courts about asking permission to appeal in order to help the courts above. It's not a mandatory requirement that you ask permission, but generally, when discussing it and seeing the reasons, that it can be helpful, and particularly helpful, should have been helpful in this case. When
Well, indeed, there is a point which isn't apparent from the papers about whether the application that was made to the High Court was out of time.
Yes, it wasn't. The application for appeal. No, there isn't. Can I address you on that? So it's by the by. You have time for the appeal runs from the last day of the assessment. So I absolutely accept that it was made in time.
Oh, there's a rule that provides that.
I can find it.
Okay.
But there is
we
no
had
point.
not understood.
Sorry.
We were not familiar with that, or at least I was not.
I can take you to the rule. I can find the rule in due course for you. But there's a good reason behind that. It's to encourage parties not to start appealing until they know the final position.
Right.
But
I'm glad I asked the question.
Yes. I'm glad I knew the answer.
Might be helpful if someone could identify the
I will make sure I do for my lady. It was out of time. There's no point that it was out of time at all. So going back to the point in my first round, and they do, in my respectful submission, pervade over each other. On either way, that if Mrs. Justice Hill is wrong, and the skeleton argument in response to this says, well, isn't Mr. Lyons, on behalf of my client, arguing about a finding of fact, and says the court will have its own view about all of that? No, I am not. And the reason why at length I referred you to Guy and Surrey is that that's not the point of the second instance judgment. It's the first instance judgment that you have to have a look at. That I say, if Mrs. Justice Hill's conclusion about that it wouldn't step over to a second day, or third day, sorry, is unsound, then the appeal must succeed. I've dealt with the point about, well, is that an attack on the finding of fact? But central to this point is the point that I made already. Mrs. Justice Hill is in no position to replicate the feel that the judge had. And Deputy Cost Judge Foxton made the point in his judgment at paragraph 11, which has been handed to you today. The judge on the ground is, in my respectful submission, entirely best placed to reach that evaluation conclusion rather than Mrs. Justice Hill. And moreover, a fact that may not be lost on you is that there's never been an appeal against this decision that has been made, nor was permission to appeal sought about that decision. I repeat all the submissions I've already made about asking for permission. So I've addressed you effectively, I say in ground one, that it's about replicating the fear, and that the phrasing in my respectful submission of Mrs. Justice Hill is that she fell into that very tempting trap that you as appellant judges can fall into. The rebalancing the scales as to what she deemed fair, which we say shows she was interfering with the discretion of the judge, rather than it being an error of law or approach. I think I've addressed you as a go along about grounds 2 and grounds 3, unless you want to hear from me further on that. What I'm going to say briefly is about ground 4. The respondent's answer to that seems to be that I didn't address that point, and it misunderstands the point, and it may be my error. That what that point is about. It is about, not about Mrs. Justice Hill, it is about the Deputy Cost Judge, that what she didn't deal with was the Deputy Cost Judge found that weighing that balance in the favour, that he was going to determine what cost sanctions later on.
Yes, is there any discussion of the cost sanctions in Mrs. Justice Hill's judgment?
There is not. You can see what cost sanctions there were applied in that judgment of the 8th of November.
Yes.
Not
indeed.
attacked and subject to appeal. So I think I've addressed ground 4 as well. The respondent's notice. I've addressed about the point not being argued. I'm going to deal with this very, very briefly. It is unhelpful in my respectful submission to start overcomplicating the application of detailed assessment with the extensive jurisprudence on Part 17. Part 17 is as self-contained as is CPR 47. But even if I'm wrong about that, nothing about Part 17 tells you that it isn't a discretionary decision. You will have all dealt with applications under Part 17 when as trial judges. Some amendments onto Part 17 are bigger amendments, if I can put it that way,
Yes.
as to other amendments on Part 17. If this was to be said to be by Part 17, it would be, somebody might point and say, well, hasn't it been prefaced there? But I say that's a trap for the reasons I have given, that you shouldn't indulge the respondent to this appeal on. Those are my submissions, relatively brief, not labouring the points, hopefully, my lady, unless I can be any further assistance. Those are my submissions.
Miss Bedford.
Good morning, my lady. Good morning, my lords. May it please the court, as you've heard from Mr. Lyons, I appear on behalf of the respondent this morning. With the court's permission and consistent with the practice direction in both the Commercial Court and the Supreme Court as well, I have carriage of this appeal in the main. However, I'm intending to delegate the issue of O'Sullivan, which appears in your authorities bundle at tab 12, to Mr. Mason to have carriage of. Thank you, grateful. In overview, the respondent's position on the appeal can be summarised in 3 points. Firstly, that Mrs. Justice Hill did not dismiss the grounds, but nonetheless allowed the appeal. Whilst I accept, of course, that this is a second appeal and the primacy has to be given to the Deputy Cost Judge's judgment, the way that this appeal has been framed through the grounds is to have a significant focus on the treatment of Mrs. Justice Hill's approach to the Deputy Cost Judge's decision. So there in my submission is a connectivity and a focus between the two, and consequently a focus required upon Mrs. Justice Hill's decision. Returning to that, on any fair reading of her judgment in my submission, she did not dismiss all grounds, and then impermissibly allow the appeal on the contra, as I intend to take this court through. Ground 1 was in fact allowed in full. Ground 5 was allowed in respect of the connected and interconnected aspect of discretion. Perhaps I can perhaps I can address that just at this moment, because what there was the issue before the Deputy Cost Judge was actually 2 issues. First of all, was the original points of dispute, were the original points of dispute compliant with the mandatory form and content requirements in practice direction 8.2 of Part 47? And if they were not, what does one do about that as a matter of case management? And secondly, whether there ought to be permission in the loosest of sense to allow the amended points of dispute in, which had been served very late, as we've heard, and only 2 working days before the hearing itself.
That's very much bound up with what you have put as part 1, though, part 2 of the first point, wasn't it? Because what do you do about Ainsworth non-compliance inevitably brings into play, do you allow the annotated schedule?
There is an interconnectivity, of course, and the interconnectivity is in respect of the second aspect, of the discretionary aspect. However, there are still, and I maintain that there is this important structure and distinction between the legal test to be applied to the admissibility of the non-compliant points of dispute and then admissibility in respect of the amended points of dispute. And that's important because the tests are different linguistically and also intentionally. So what one can't do is apply the 1310 test to whether the form and content of the original points of dispute have been complied with. That's the first point. But the second point in my submission is where the interconnectivity particularly comes into play, because one has to answer these questions sequentially. The reason for that is if there is found to be a breach of the practice direction in respect of the original points of dispute, that they do not comply with form and content, such that the amended points of dispute are curative of that defect, that directs towards a finding that the original points of dispute are non-compliant, but otherwise that there has been a breach of the practice direction. Once one finds that there has been a breach of the practice direction, that in my submission is directly relevant to the overriding objective and its application, which of course informs the case management decision, both in respect to the...
Sorry, I think you're going to have to slow down.
Sorry.
Slow down slightly for my note-taking. I've got the point, you've got to answer the sequentially. If there's a breach of the... if the original points of dispute are non-compliant, such that the amendment is curative, that, I think you said, directs a finding that the original points of dispute are not compliant and there's a breach of the practice direction.
Yes.
Then,
in respect of applying the overriding objective, breaches of practice directions are relevant. And that informs how the court exercises its discretion.
So this isn't, you sometimes get an amendment not in the cost context, and the question is simply, can I introduce this new claim or defence or not? But you're saying here, the issue of variation arises against the background of a prior finding of non-compliance with the practice direction.
Absolutely. And in those circumstances, that finding of the breach and non-compliance is directly applicable to the secondary question of discretion, both in respect of what one does to admit or whether one ought to strike out or dismiss the non-compliant points of dispute, but it's also then relevant to how one treats the amended points of dispute, which are curative in this instance, and that in my submission the breach and the reason for the breach, the length of time upon which the breach has been notified of, all become relevant to factors to admit the curative amended points of dispute. So once one in my submission breaks the actual test down as a matter of principle and as a matter of procedural law and how one approaches it, what one sees is that this is not a singular question of case management, which is how the appeal is currently framed. The question before the cost judge was twofold. And when, I'll take you through this.
sorry, this is not the way Mrs. Justice Hill approached it.
In my submission, my lady, it was the way that she approached it.
Well, no, because in the the key decision was effectively to look at grounds 1 and 5 together and look at not distinguish in the way that the deputy judge appears to have done between the strikeout of point 23 and the permitting reliance on the schedule.
Perhaps, my lady, I can take you through the judgment itself, because what, in my submission, Mrs. Justice Hill does is precisely the way that I've just characterised it. She deals with ground 1. If you can turn, please, to page 48 in your bundle. What you'll see here is that Mrs. Justice Hill interprets the rule that is before her. So she addresses the legal question. This is the Ainsworth compliance question. So she frames up the ground at ground 1 at paragraph 67. She then addresses the question of Ainsworth. And
Yes. She clearly does decide that they're not compliant.
And that's important, because one of the aspects of the criticisms, and it's a fair criticism and one which I maintain, is that the Deputy Cost Judge did not deal with the question of compliance at all. But what one sees in terms of the structure...
Well, okay. Right.
Isn't it implicit in the deputy costs judgments that the points of defence were not Ainsworth compliant? Because you would not have been needing to, if by definition the points of defence were such that the receiving party had all they needed to do to conduct the case, then there would have been no need for the amendment, no need for the adjournment, and Mr. Mason could have dealt with it. So very premised in those decisions is it didn't do what Lady Justice Appellant says a document of this kind has to do.
The treatment of it is at page 155, and you'll see at paragraph 15 this is the closest, and this, in fairness, I think picks up on the point that my lord has just made, that it is implicit. But what he does at paragraph 115 is he says, whilst it applies in principle, he says the original points of dispute would nonetheless have allowed there to be a fairly broad brush assessment. I'm going to put a pin in that for a moment, if I may, before I return to Ainsworth, where the treatment of broad brush is dealt with. But it doesn't go on expressly to deal with the fact that there has been non-compliance. And that, for the reason that I just set out a moment ago, is important, because it then does not direct towards the reality that there had been a breach of the practice direction, which then informs and frames as a relevant factor how one exercises that discretion. What he does instead is focus on the curative effect of the amended points of dispute. In my submission, had he determined that the original points of dispute were non-compliant, then it would have directed him towards that being a relevant factor to have regard to within the exercise of his overall discretion. He then outlines only 2 reasons for refusing to admit the points of schedule, for refusing to strike out the original points of dispute.
Doesn't the second one somewhat reinforce the point my lord's just made? There should have been a further document.
If I may, that the way that actually arose, perhaps if I can take you to that, is which you will find behind tab 20 at 353. That's the annotated document itself.
Yes, well, and we know there's a reference. Yes, we know there's a reference. If you
look at the language at 347, which is the way that the objection is treated in the points of dispute. What one will see 4 lines down is the defendant will rely on an annotated document schedule in support. That's the future tense. It's not the present tense. It's not, and I don't think that there's any disputes on this, it's not that the annotated document schedule was a component of the original points of dispute. It was that some points in the future, the defendant intends to set out their arguments in full. And what they don't do is actually foreshadow the granular nature of the objections that they intend to set out. But otherwise, it doesn't comply with the form and content. So whilst they foreshadow that a document will be arriving, they do not send it at the point of the original points. So as a consequence, the original points of dispute were not compliant for the reasons that Mrs. Justice Hill sets out. And what one sees if one goes back to the decision of the cost judge is that he does notionally deal with at paragraph 8, which is at 154. Sets out here relevant factors. He accepts that the schedule, although does broadly reflect the general categories, but just pausing there for a moment, for the reasons expressed in my skeleton, the categories were in fact different categories. He accepts here that it does go beyond those categories, and certainly it provided significantly more detail than was in the original points of dispute. So whilst there was a foreshadowing that at some point in the future there would be compliance with the practice direction, it wasn't at the required time in line with the timetabling for detailed assessment proceedings. In fact, it comes substantially after, by some order of around 7 months. There has never been in my submission any real explanation for that delay. There are 2 reasons broadly given for why why there has been that delay. First of all, the explanation given to the cost judge is at page 162. That explanation you'll see between A and broadly D. The explanation is that the parties were in negotiations, and you'll see importantly that it's expressed to be in negotiations shortly before the hearing. What that does not explain is why 7 months earlier the schedule had not been attached, created, provided. In short, it doesn't engage with the critical aspect of providing an understanding as to why the practice direction at the critical time was not complied with. It simply says that there were negotiations ongoing. If one compares and contrasts that with a transcript before Mrs. Justice Hill, there is ever so slightly a different reason given. Sorry, I just lost my page reference on that. Just bear with me a moment. The reason given before Mrs. Justice Hill, I'm just going to find that page reference for you, is that it had 2 reasons were given. The same reason is repeated, but it is also stated that the reason was that it was overlooked. And that is at page 94 of your bundle at A to B. And if we take, of course, the line of authority from Mitchell through to Denton and the sea change that occurred on the 1st of April 2013, following the architect, of modern litigation and the Jackson reforms, overlooking a matter of procedural necessity and particularly in terms of form and content, in my submission, is simply not a good reason at all. Perhaps this is a useful time, if I may, just to take you to, just to underline that point in the authorities. If I can take you, please, to what it may be a particularly well-known judgment, particularly within the constitution of this court, which is Mrs. Justice Carr, as was decision in Kwa Su Ling. You'll find that behind tab 9 of your bundle. If I can take you, please, thereafter to page 101 and paragraphs 37 through to 38. Now, I accept that this is in respect of the authorities under Part 17 and late amendments. But what we have here in my submission is an understanding of the difference between past regime, particularly following the Wolf reforms, or particularly, forgive me, prior to the Wolf reforms, which were enacted in order to ensure that litigation is conducted more efficiently. We have a period of around 10 years, as is well known, where those lofty ambitions perhaps were not achieved to the extent to which it was hoped they would be achieved. We then, as a consequence, have the Jackson reforms, and importantly, 2 points from this. One can see from the change to the overriding objective on the 1st of April 2013 included 2 functional, important primary changes. Number 1, to expand the understanding of the overriding objective to include running litigation at proportionate expense. But also, importantly, 2, there was an insertion of subsection G into the overriding objective at 1.1, which underlines the requirement of the overriding objective to have regard to enforcing compliance with rules and practice directions, which comes back and circles back to the point that I made to my Lord when I first rose, which is that there is a requirement and an importance attached to complying with rules, practice directions to parties in litigation generally. But more importantly, this is a requirement that the court has to have regard to when exercising its case management powers. This, if I may, is the context where I bring you up to in respect of Kwa Su Ling. We then get to paragraph 37. Mrs. Justice Carr sets out a number of authorities which, in my submission, she properly characterises as well known. Importantly, you'll see therein Swain and Mason, but you'll also see reference to Mitchell and News Group newspapers, which of course was a decision, very well known decision of this court back from 2013, which appears at 1537 of the neutral citation. She then goes to draw principles from those authorities. Under subsection A, exercising the discretion, the overriding objective is of the greatest importance. B, she sets out that there is a heavy burden on the party seeking a very late amendment to show the strength of the new case and why justice to him, his opponent and other court users requires him to be able to pursue it. The risk of a trial date may mean the lateness of the application to amend will of itself cause the balance to be loaded heavily against the grant of permission. One then gets to see the very late amendment provisions. D, lateness is not an absolute but a relative concept. Then E, importantly, this is one of the first of the two subparagraphs that I rely heavily upon. Gone are the days when it was sufficient for the amending party to argue that no prejudice had been suffered, save as to costs. That, of course, being the imposition of the sanction to an extent that the Deputy Cost Judge applied. Mrs. Justice Carr here, having reviewed this court's authorities, particularly in Swain Mason and Mitchell, says that that approach is no longer potentially sufficient. In the modern era, it is more readily recognised that the payment of cost may not be adequate compensation. So this is the reflection of the sea change that one sees between the embryonic civil procedure rules from 1999 and the evolution of those through the 1st of April 2013. Importantly, if I may just pause here and just deal with the Bigutti point, Bigutti point. Bigutti, of course, was a case decided in 1999 when the anticipation and expectation of the civil procedure rules in their embryonic form at that point was high. The intention was to create a new system which would, through the greater application of case management, create a system where parties were proceeding in a more orderly fashion. Unfortunately, that did not occur. But what one sees is that Bigutti, in my submission, is from a prior time. It no longer, in my submission, is reflective of the current modern approach to litigation. And the reason that one, in my submission, arrives at that as a conclusion, in particular, is through the effect of Mitchell. If I may take you to that now, it's set out verbatim at subsection G, which you'll find at page 102. What one has here is a direct citation from paragraph 39 of Mitchell. Importantly, that citation itself directly cites from the 18th implementation lecture of the then Master of the Rolls, when he was doing his circuits, speaking on the effect of the Jackson reforms. What one will see here, if I may, appreciating that some significance is attached to this, what one will see is a much stricter view is now taken of non-compliance. 2 points on that, not only the stricter view, but it underlines the issue of non-compliance, which in my submission circles back to the point that it is important, if there has been non-compliance of rules, that it is reflected and determined within judgments, because if one does not do that, one consequently, for the reasons given, cannot arrive at the conclusion of exercising the overriding objective correctly in its new and current form. The achievement of justice means something different now. This is the direct citation from Mitchell. Parties can no longer expect indulgence if they fail to comply with their procedural obligations, because those obligations not only serve the purpose of ensuring that they conduct the litigation proportionately to ensure their own costs are kept within proportionate bounds, but importantly, but also the wider public interest of ensuring that other litigants can obtain justice efficiently and proportionately, and that the courts enable them to do so. When one applies that to cost litigation, in my submission there has to be, and it underlines, the compliance with 8.2 of the practice direction. 8.2, in the form and content requirements of my submission, are of manifest importance. I'll take you through Ainsworth in a moment, but just to underline the point before I move. This, of course, is where the defendant, the paying party's objections are set out. It serves two functions. It informs the receiving party as to the challenges that they will face on an assessment. That allows them equally to have three responses themselves. First of all, to allow them, in accordance with the rules under Part 47, to prepare their replies. That is important in and of itself, so that when the composite document which is referred to as precedent G, in reality, it looks like a Scott schedule. It sets out the defendant's objections and the receiving party's response. That then informs, so it creates the composite scope and four corners of the arguments before the court. That in and of itself then informs listing. It gives the court an understanding as proper as to the four corners of the argument that the court has to dispose of. If the substantive objections are either non-compliant or missing, that's going to have a negative effect upon the court's ability to properly list and understand the objections, and to tie that point back into the issue as to the wider public interest. The court cannot list on proper principles, trusting that which is within the four corners of the points of dispute and reply, compiled into precedent G as a composite document. Then exactly, in my submission, one of the outcomes, which is a negative outcome in my submission when categorised properly, is that one will face adjournments. The adjournments, of course, then have a knock-on effect not only on the parties' micro ability to proportionately deal with the case in front of them in terms of having an expectation that their hearing will be fully conclusive, that they will know the points they have to meet so they can prepare properly for them, and importantly, that they will be able to properly assess any offers which are made. And take this case as a paradigm example. The offers came in from the paying party prior to the receiving party having full knowledge of what those objections are going to be. So one has a significant disconnect between what the pleaded case is and what the constituent offer. Yes, my lord.
That is a reason why sometimes people seek, as a condition of allowing an amendment or variation, a requirement that means that for the purposes of assessing the effect of any Part 36 offer has been made, matters are to be judged by reference to the position at the date that the offer was made, or an opportunity to make a further offer that would take effect as though from an earlier time. So there are other tools in the judicial toolkit to deal with the effect of quantum amendments of various kinds on prior Part 36 offers.
But in my submission, my lord, the toolkit is a broad box. Mm-hmm. It has a multiplicity of different tools in it. What we're now told is that when a court reaches for the tool that says cost consequences on it, it ought not to do that as readily as before, but addressing the point directly. It doesn't take into account that when one is considering the offer at the point it arrives, one ought to be in a position to be able to assess that in completeness, because the putting the parties on an equal footing, the defendant is fully aware of what their arguments are likely to be when formulating and making the offer, but the receiving party, having received that communication, has been deprived of relevant information to be able to assess properly that offer.
Taken to its logical extreme, though, this would mean you never get to vary points of dispute. Now we know you do. It's all ultimately going to be, it's a nuanced decision by reference to a number of factors, isn't it?
These are nuanced decisions, and I don't pull against that. But one of the primary considerations is whether there has been compliance with the rules, and if the point that my lord just makes is taken to its logical conclusion in a different context, it means that a paying party will always be free to be able to make offers contingent upon arguments which are concealed at that time.
Well, I think are you overstating it by saying always free? The appeal is put squarely on the basis that essentially the deputy judge was entitled to deal with it in the way he did, not inviting this court to endorse that as the only or indeed preferred approach.
Yes, my lady, but if I may, Mrs. Justice Hill, quite properly, and I appreciate we've probably been pulled off the point a little at this juncture, Mrs. Justice Hill finds that the cost judge failed as a matter of principle to apply the correct test. That, of course, is an error of principle, which is, in my submission, fundamental to the appeal itself, because not only did she find that there had been an error of discretion, but that error of discretion was informed due to the failure to apply correctly the principles in Ainsworth and the form and content requirements of 8.2. And just, if I may, just to step back for a moment and answer the question, it is, of course, always to complete the submission as to reaching for the appropriate tool. It is, of course, always going to be available, but in my submission, the flexibility comes in, particularly when one is given a good reason as to why there is an amendment that has been made. So in the instance that my Lord gives me, well, there is always the ability to amend the points of dispute, and in certain correct circumstances, or forgive me, appropriate circumstances, one can visit the appropriate consequences through the prism of costs. That may be the case but a factor to weigh in the balance when arriving at that decision would be the reason for the amendment.
It's certainly a relevant factor, but litigation being a human activity, errors are made, and I think the effect on the professional indemnity market, if they automatically led to no curative measures being permitted, might be quite dramatic.
My Lord, if I may, the parties ought not to be able to fall back on their indemnity insurance in those situations. There are direct references in my submission within bar suing to the requirement to enforce rules and practice directions. And if there has not been a good reason as to why there has been non-compliance, and the reason, of course, may be a number of different aspects, and it has a spectrum. At one end of the spectrum, there may be, in my submission, directly related to Mitchell, of course, there may be no good reason. Equally, the reason given may be that it's been overlooked. One has to weigh that qualitatively in the balance. At the other end of the spectrum, it may be that, by way of example, the receiving party provides documents a few days before the assessment, which puts a new argument before the paying party, which then necessitates the amendment itself. But the differential here is the qualitative approach to assessing and weighing the good reason. But one only arrives at whether one consider whether there is a good reason for the breach if one first of all deals sequentially with the existence of a breach itself. And what one sees in my submission as an error within the Deputy Cost Judge's process in refusing to, we should go back please to 155 in your bundle. What you will not see here, first of all, is this, he deals, just as a matter of orientation, if I may, first of all deals with the strikeout of the points of dispute. You then go from paragraph 15 to 17. Then from 17, or the last sentence of 17, from 18 onwards, deals with the admissibility of the amended points of dispute. But the answer to the question of admissibility of or compliance of the original points of dispute is at paragraph 15. And what you do not see there is any express reference to the overriding objective.
Well, at 16, he finds both parties are significantly at fault for having failed to comply with the overriding objective.
Yes, but that's contained within a narrow viewpoint.
Well, he plainly formed the view that the paying party was significantly at fault for failing to comply with the overriding objective, didn't he?
Yes, absolutely, and that was a material and heavy factor. But had he appreciated or given himself direction initially that the overriding objective as an important constituent part included a failure to comply with the practice direction and the
Sorry, can I make sure I understand this? Your criticism is that he doesn't deal with the overriding objective at 15. Is that right?
And 16, my lady. I accept that he references it tail end of paragraph 16. But the context is that the identified failure of the overriding objective is to get their act together earlier. What one can't see implicitly from that is that he's also had regard to the other factors of the overriding objective.
You're really getting back to the need to comply with rules, aren't you?
And proportionate expense, absolutely, my lady. And that both the micro and macro effect of complying with the overriding objective, and the need for proportionate cost control, and ensuring that matters are dealt with expeditiously and fairly. If one looks at the context of how the deputy cost judge treats it, the overriding objective as he weighs it in the balance, what he's talking about here is the party's duty to liaise with each other and the court, which of course is under 1.4, sorry, forgive me, 1.2 and 1.3. 1.3 being the duty of the parties to help the court further the overriding objective. So he's talking about the communication.
Is that really a fair description of what he's saying here? I mean, he must be taken to be aware of what the components of the overriding objective.
But the material factor here, as one can see actually, are from paragraphs 8 and 9, if one goes back a stage to page 154. What one can't see is, having recited these facts, the submissions and the factors here, you'll see in particular that about halfway down, this
of
is
which paragraph?
Of paragraph 9, my lady. This is in circumstances in which the claimant is already prepared for that hearing and has already prepared a bundle. That was in part based on the general points that were set out in the points of dispute and the difficulty Mr. Mason would have to deal with the new additional amended points of dispute. What one doesn't see when he says there are 2 reasons, which one goes back then to paragraph 14, is that he doesn't have any sufficient regard to those important factors, nor does he have regard to even giving it lip service. The proportionate cost of having to go off into a 3rd day. So where he speaks about the overriding objective at paragraph 16, it's in a more narrowed understanding as seen through the prism of 1.3. Now I accept here that one, of course, when making judicial determinations, does not have to slavishly move through the factors of the overriding objective. But what one does need to do is have transparency in judicial thought process and have regard to the relevant factors when weighing them in the balance. And what one can't see in my submission here is full treatment of those relevant factors, in particular the effect on proportionality of incurring a further day, and also the treatment that also the effect on the receiving party for not having their case concluded at the appropriate time, nor indeed because there has been a failure to identify that there has been a breach. As my lady quite pointed out, the primacy of that position. Had he identified that there had been a breach, he, in my submission, ought to have gone on to ask himself whether there is a good reason for that breach, and then weigh that up within the melting pot of then determining what an appropriate outcome is. If there is no good reason, in my submission, there is no reason at all put as to, at the point of the points of dispute being drafted, why paragraph 8.2 was not complied with. We have, by way of explanation to the deputy cost judge, that the parties were negotiating, but that doesn't explain what was happening 7 months prior. We then have the explanation to Mrs. Justice Hill, which is that the schedule was overlooked. If one weighs that in the balance, in my submission, that directs, as we've seen through Mrs. Justice Carr's decision in Kwasu Ling, and also Mr. Justice Coulson, as was decision in CIP Properties, as to why that is no longer an appropriate position, even if there is a good reason. I take you broadly through very quickly just to highlight it so it's read into. It's a paragraph 81.
81.
Of the authorities, forgive me, page 81 of the authorities bundle.
You sidelined 19, is that it?
Yes, it's a page 81, my lady, that's it, correct. It's paragraph 19, exactly so. And importantly, subsection C, over the top of page 82, the relevance of the history, together with an explanation for its lateness, is a matter for the amending party, and it's an important factor in the necessary balancing exercise. In essence, there must be good reason for the delay.
One point that might be made is that under Part 17, positive agreement of the court is needed to any amendment.
Absolutely. If I can address you very quickly on that, if
and as Mr. Lyons has said, there is quite a body of authority now.
Just dealing with the differential between 1310 and Part 17. Part 17, of course, is engaged with amendments, as is 1310. I come back to my first point, that there were two distinct questions before the cost judge because there were two different procedural tests. But just focusing on the permission for the amendment, I accept immediately that there is a linguistic difference between Part 17 and 1310. 17.1, of course, requires that no permission if claim form has not yet been served. Subsection 2, permission is required if the statement of case has been served. 1310 itself, which you will find in your authorities bundle at tab from page 15 onwards, at tab 2.
Page 19.
Yes, lady, thank you. It's page 19. You'll see there that permission is not required, but the court may disallow or permit only upon conditions. This is a very wide discretion denoted by the word may. I accept that. That's one of the factors that was found in O'Sullivan, which Mr. Mason will address you on in due course. The function and the purpose in my submission on that language there is that, and again as found in O'Sullivan, is that it is not, permission is not required. But if one looks at it in my submission, what one has is that it is still a discretionary exercise, and the court may disallow the variation or permit it only upon conditions, including conditions as the payment of costs. But the objection of it still has to be exercised through the overriding objective because, of course, of the permanence of that rule. So it still requires, in my submission, an examination of the same relevant factors in terms of the operation of the overriding objective that Part 17 has, because of the pervasive effect of the overriding objective throughout the the civil procedure rules in general.
Thank you.
So there is still some utility. Whilst the legal test may be different, the overriding objective and the connectivity that creates between Part 17 and 1310 is why in my submission the treatment of how one frames and directs discretion which have been given by the commercial court in Barsu Ling and CIP properties has substantial utility. And in my submission, just making that point and completing it, it would be an unusual step if the discretionary exercise, so the judicial function of exercising the discretion under Part 17 to dispose of the overriding objective is different to the disposal of the overriding objective within 1310. Whilst Mr. Lyons says these are all self-contained codes, in my submission that doesn't, somewhat beside the point. A self-contained code creates a procedural framework.
Okay, well there may be this, which statements of case under Part 17 are really intended to establish the scope of the trial, if you like.
Yes, which is the same function and purpose of the points of dispute and precedent G for framing the...
Yes, but in the context of a trial, it tends to have implications that include the scope of witness evidence and disclosure.
That's the treatment, if I may, of evidence. There is still whilst detailed assessment proceedings themselves don't have the treatment. Let me step back, if I may, just for a moment before I make that submission. There can always be witness statements in detailed assessments, depending upon the point which is put. One can see a treatment of that, particularly within Celtic, because one of the points in Celtic was if you're going to be raising the indemnity principle and retainer point, it may be that we need to put a witness statement in. So whilst it is not certainly expressly provided for in the regime of Part 47 to allow witness statements in, it can still be the case that witness statements are made, depending upon the point. But in my submission, this comes back to the issue of ensuring that there is compliance so that the receiving party and the court, when listing, in the process up to the detailed assessment, are fully aware of the four corners of the argument. That is but one particular example. But more pertinently, is on a general and a more typical assessment. If the receiving party prepares the bundle is usually extensive. It goes through all of the attendance notes and correspondence contingent upon the objections. The reason for this is that the papers in support of the bill, which is expressly put forward in the practice direction at 13.11, which is sidelined at page 19 of your authorities bundle. You'll see there that the bundle has to be filed no later than 7 days before.
Yes.
So where one gets very late amendments, as here, one can readily end up in a situation whereby the bundle has already been prepared and filed, but yet the objections now disconnect in the event that the late amendments are put in. 2 points on that. First of all, obviously, in the event that the evidence as framed by the documentary evidence is not in the bundle, that's going to cause the receiving party a difficulty, in particular a difficulty on a standard basis assessment. The court, again, forgive me if I'm appreciating that the cost jurisdiction is quite an esoteric area. The standard basis, albeit I anticipate the court will appreciate or certainly be aware of this point, the standard basis assessment is that the doubt, in the event that there is any doubt, is resolved in
I think we did
that.
cover that.
Yes, but the way that it affects in practice is that if a receiving party can't take the court to a particular document to assuage that doubt, then it will be disallowed. So if an objection is raised late, it's no documents are present in the bundle to address it, then the rules compel that the doubt must be exercised in favour of the paying party. We can see the unfairness there. Equally, of course, what could then happen if the bundle is prepared and there is a disconnect due to late amended points of dispute, is that the receiving party will have to develop potentially a new bundle at a very late stage, and all of this is during their preparation time, when really they ought to be focusing on what's already been objected to.
These are absolutely the problems that late amendments cause. I don't think they uniquely or specially cause them in the costs jurisdiction, but in other contexts it can lead to, as you say, adjournments. It can lead to fresh or additional bundles being required and so forth, and that, you know, plainly all has to be brought into the balance when deciding whether to permit them.
Absolutely, my lord, and that's one of the points. That is one of the points in my submission which weighs against the amendment being allowed in. And just to underline that, if I may take you to page 82 of the authority bundle, this is CIP properties. It's under subsection E, and it's the prejudice to the resisting parties, in particular the disruption caused during preparation.
Sorry, C?
Sorry, E, forgive me.
Yes.
Again, these are particular features which ought to be given weight, and if one cross-references back to the Deputy Cost Judge's decision, they are stark from their absence.
Well, he says the bundle's already got the documents in, but he's adjourning anyway, isn't he?
Can I deal with the bundling issue?
Yeah.
There are two bundles which were prepared. One was prepared in respect, bundle 2, was prepared in respect of the original points of dispute, and it was prepared reflecting those. This, of course, being 7 days before. What there is also a requirement to do or an understanding of usual practice, is that the entirety of the papers also get filed as well. But if one then has, as one here, if I can take you just as a matter of context to page 353, which is the amended document schedule, one again gets this in. So the bundle has already been prepared. Let's speak to bundle 1, which has every single thing in it. Bundle 2 is directly prepared by reference to the original points of dispute. The amended objections then come in 2 days before, and you can see the extent of them. They go to 24 pages. What is then required is a cross-reference between these new objections and bundle 1, which has everything in it. That, in my submission, is a significantly laborious task. And what that does is, if one has to stop preparation of the original points of dispute on bundle 2 and drop on to preparing these new objections, which are extensive and granular, 2 days before by reference to bundle 1, one's going to have to find every single item to correlate with this. That, in my submission, directly feeds in to what then Mr. Justice Coulson speaks of the disruption and pressure in the run-up to trial and the dealing with amendments. I may just pause here since we're on it and deal with the amendment, the bundling issues. At paragraph 24 of the judgment of the Deputy Cost Judge, he treats this issue this is where the mildly treatment comes in. It's at the bottom of page 156. He then says over the page that criticism pales into insignificance in respect of the parties colloquially not getting their act together. So in my submission, what that in context says, putting it quite shortly, is that it's a minor issue and that he attaches minimal weight to it. I can then take you, please, to actually, there is the treatment, of course, and the inconsistency within the cost judgment that your ladyship and your lordships asked for yesterday, where he inverts that finding.
No appeal against the costs order he makes, though, is there?
Well, there is not, as a matter of fact, that is correct. But I suspect that logically, if this appeal succeeds, or if this appeal is upheld, then of course the matter is remitted, so the cost order falls away.
But it does make it quite difficult to argue that he made an insufficient allowance for this and the costs order made at the end of the November hearing. That would have required an appeal against that costs order, wouldn't it?
Insofar as they're interconnected to a point, of course, in my submission. But what one has is, in the event that this appeal was overturned, as Mrs. Justice Hill did, of course, the underlying judgment disappears, and so that has the knock-on effect upon the costs order. It may be that there are always numerous reasons why parties don't take appeals on anything. It may be that it was thought that this was perhaps the full effect, and where the claimant would have the full effect of overturning the judgment rather than simply just the costs order. But if one goes back, if I may, to paragraph 52 of Mrs. Justice Hill, this is at page 45 of the report bundle. You'll see there that actually what the treatment on the cost judgment does is that it misremembers.
Just trying to work out where that goes on this.
Well, exactly, my lord, and there is force perhaps in where that thought process concludes, because of course, as you rightly identified, the cost judgment is not under attack. Equally, the reasons for the cost judgment are not reasons to uphold this order. So if I may, my submission is that the treatment of it and the utility of it would be to assist in the interpretation of the original reasons. But that only comes into play in my submission in the event that there is an ambiguity, or that the original reasons are not sufficiently tolerably clear. In my submission, we don't have that. His reasons, as expressed, were particularly in respect of both questions. So first of all, the question to admit, strike out the original points of dispute. He expresses those clearly at paragraph 15 and 17. It's not that they're not expressed clearly, it's that in my submission they're simply wrong in principle and don't weigh fairly balance the correct factors. He then treats the admission of the amended points of dispute thereafter from paragraph 18 onwards. So they are tolerably clear in that respect. So for those reasons in my submission, there is minimal utility in the cost judgment itself as a matter of principle. But even if I'm wrong on that, as a matter of discretion and weight, I invite this court to put minimal weight on it, because of course he misremembered. So as a treatment of fact, given that error, there ought to be either no weight on it at all or minimal weight. What is absolutely critical is that at paragraph 24, going back to his judgment at 156, the treatment of the bundling issue was a minimal factor in his consideration. Whilst I'm here, if I may, if I can just deal perhaps with a counterfactual. There is some criticism from the appellant that the cost judge wasn't asked, well, what would you have done in the alternative? In my submission, that's actually addressed at paragraph 25 of his judgment. This is at page 157. Here he deals with the counterfactual, which is contrary to his findings. If he had disallowed the amendment, he says that Mr. Mason would still have been in difficulties, as he would have to have proceeded by reference to what is said in the original points of dispute. Well, the reason that Mr. Mason submitted that he would be in difficulties dealing with the original points of dispute was because they were non-compliant with Ainsworth. That was not the bundling issue.
But what the breach here is the service of a non-Ainsworth compliant points of dispute. The counterfactual is what would have happened if the material had been served as it should have been. And isn't the cost judge saying it would have been a 3-day hearing?
No, my lord, if I can take you back to it, because he talks about disallowing the amendment. He doesn't talk there about disallowing.
No, but analytically, why isn't that the correct approach?
Well, the reason that it's not a correct approach, if I may, is that what it does is it conflates the position of allowing the amendment in with the position on the dealing with the original points of dispute. He says, if I had allowed the amendment, i.e. allowed the amended points of dispute that were served 2 days before, and I get the strong impression Mr. Mason would still be in difficulties if he would have had to proceed by reference to what is said in the original points of dispute. So there is an internal inconsistency.
Well, yes, but there's a different point, which is you're saying, in fact, it seems to be common ground, that the original points of dispute were not compliant. So if the annotated schedule had been served with the original points of dispute, presumably no one would be saying that there was non-compliance. If that schedule had been served, it appears that the deputy judge has taken the view, and appears to have been Mr. Mason's view, that there would have needed to have been a 3rd day to deal with it. That's the point.
Yes, my lady. That if I may, it's perhaps a more nuanced point than that, because that then doesn't, whilst that potentially would have been the, well, if I may...
I'll put it another way, that's the criticism being made, or a criticism being made of Mrs. Justice Hill's judgment.
If I may, the extent of which it would have potentially impacted upon the 3rd day or not, if the full points of dispute or the amended points of dispute, in their totality, their fullness, were gone through in detail, then of course one could have said that it went to a full 3rd day. What happened, what that was depriving the receiving party of, was at the relevant time, in compliance with the timetabling, putting in their replies. Now, it may be, because we don't know, that those replies may have conceded some aspects of the objections which were put to them.
But was much conceded between August and November?
Well, my lord, I was going to come on to that point, if I may, in a moment. At the point of which there ought to have been the replies, there could have been concessions. There may have been concessions, we simply don't know, because the receiving party was deprived of that potential. You're absolutely right, and my secondary point was going to be, well, what in fact happened thereafter? You're right that there weren't any replies put in, and the objections were taken in full, which required the full 3rd day. But by that point, of course, the horse had already bolted out of the stable.
I mean, you certainly have the point that there's a difference, I think most people would recognise, between a 3-day hearing of 3 consecutive days and 2 days, and having come back a few months later and work the case up again and do day 3.
Absolutely. But then equally as well, of course, the further point on that is that by the point that the amended objections were allowed in, the receiving party, and we've gone through this hearing, the receiving party's already incurred all of those additional costs in any event, and it may have been taken as a view that there was going to need to be, because of the effect of the offers that were on the table, an ability to argue those objections in full in order to meet the prior offer that was made.
Am I right that it was 100 and 105 being 2 competing Part 36s? But the 105 meaning if you beat that, you would get all the benefits that flow from the claimant beating its own Part 36, and for the paying party, if you fail to beat 100, all the benefits flow from that. So I suspect, given that narrow swing, there was an incentive to every point was potentially quite important.
Absolutely, my lord, and that comes back to the deprivation of the receiving party to properly weigh up the effects of an offer when it's made based on the content of the points of dispute as at that point. And just
but hang on, was any of that argument put below? Because, for example, it's it might even have been relevant at the 8th of November.
I can certainly find that out for you in relation to the 8th of
But,
November.
one has to be conscious that we're hearing arguments. Ultimately, this is a question of whether the deputy cost judge was entitled to reach the decision that he did. At that time, he would have not known anything about Part 36 offers.
If I may, I'm just finding the reference in the transcript where he is informed. I'm told it's 243.
This is in front of the...
This is the November hearing.
Okay. But this is the November hearing.
Yes. So here is the reference to the Part 36 offers.
But he's got to be told of them then, because you've got the
Yes.
argument as to whether you get who gets their benefit.
Absolutely. And he is also... I'm just having that matter turned up for you. There is a reference. Yes, I found it. It's at 161. So this is the hearing before the judge in August 2024.
161. Yes.
This is where there is discussion as to there's no prejudice, but you're perfectly entitled to take this into account. This is from Mr. Lyons in respect of our cost of the assessment and later on.
Yes.
And then he goes over the page to page 162. This is where the explanation as to the delay is given.
Yes.
And there's reference here to the parties discussing matters and that there is offers on the table, but I can't say anything more to you about that because obviously you should not know anything more about that.
Right.
Am I right in thinking that the offers from both sides are probably a pretty common backdrop to detailed assessments, and as an experienced cost judge, the deputy cost judge is likely to have thought that would be the case.
What, that there were offers on the table?
Like there were likely to be.
Correct, yes, absolutely. And also, of course, the overriding objective itself requires the parties to negotiate, and there's an express requirement to do that, though. What may be of some utility in your judgments when taking this point into regard at this moment in time is to know the fiscal effect of the amended or the objections to the amended objections themselves. The profit costs in totality were £78,446.50. You can see this from the bill at page 263.
Yes.
And if one looks up the page to the top figure, you'll see 38819.
That's the work on the document.
That's the work on the
Yes.
documents, absolutely. So the fiscal effect of allowing this objection in, between the differential of non-compliance, original points of dispute, where the court strikes commonly these objections out for non-compliance with Ainsworth, to the differential to the objections coming in and being able to be taken into account, is the order of 38,800.
No, hang on, it's not, is it? It's whatever the, it's less than that.
It will be, but it's the total effect of the argument. So the argument is, so...
Sorry, I may have completely misunderstood you, but
I'm probably expressing
the defendant paying party was never did attempt to argue that none of the 38,000 should be payable.
No, they offered something in the order of around 50 hours, which you can see is substantially less than that which is contained at 292. Forgive me, my lady, yes, I see your point that I've done the maths incorrectly, which is my fault and my error. But my point is this, you can see the fiscal, it has a significant impact on...
Your point is simply, as I understand it, that work on documents is a large component of the profit costs, and the defendant's objections would, if upheld, would have eaten into a substantial proportion of the work on documents.
Absolutely.
That's your point.
And a further point which is aligned with that is the impact it has upon consideration of the offers. And one, if I may submit this, that there is an inherent unfairness which also then arises from that, which is the point I made earlier of not bringing and putting your full cards on the table at the point, in terms of the extent of the arguments intended to be raised, at the point of which the original points of dispute are presented, which then allows the consideration of the offers in full knowledge of the arguments which one will have to face. If I may, at this juncture, take the court through the issue of Ainsworth. You'll find this.
Can I just check what we're going to this for? Because my understanding is that there isn't a dispute before us that in their original formulation, the points of dispute were not Ainsworth compliant.
Absolutely, my lord, that is entirely correct. But what is in dispute is the appropriate sanction which ought to follow. And it may be of some utility. If the court doesn't need it, then I won't take you through
Well,
it.
they took the view that the sanction fell within that broad range of discretion open to the judge, didn't they?
One of which was striking out. Absolutely.
No one's denying that was an option.
It is an option, but in my submission, it's signposted towards being the correct option in these circumstances, particularly in circumstances where we have, in Ainsworth.
Are you saying Ainsworth signpost strike out as the appropriate option?
It signposts it to being the option. Perhaps, well, it would be an issue of two arguments whether I'm putting too high a gloss on it. If you go please to 129, this is paragraph 42 of the judgment.
Okay.
You'll see here that the sequential question of was the master wrong nonetheless to dismiss the assessment in relation to point 10. one goes to paragraph 44,
Sorry, I misheard you saying 42. It's 44
it starts
you
at
want.
42. Forgive me, no, it starts at 43 and one gets to 44.
You want 44.
There are 2 points here. The first point is that which my lord had already had, which is that this is a discretionary decision. It's entitled to form the value judgment. And importantly, thereafter, if one goes to where it says the Chief Master was entitled to decide,
Yes.
and that it was not possible to conduct a fair hearing on the basis of the points of dispute 10 as pleaded, and the matter could not be conducted fairly on the hoof and was likely to take too long.
Yes. Entitled to decide.
Yes, if I can then take you to the similarities between these points of dispute and the ones in Ainsworth.
Is that an appropriate use of authority, though? It's this sort of attempt in discretion cases to say, well, let's look at these facts here. It's been deprecated in a number of contexts because it leads to citation of authority not for legal principle, but try and say, well, look, the facts of that case here are similar in some ways to ours.
But the attack on the decision here is that the discretion was exercised incorrectly. I'm merely taking you to it to the point of being indicative. If there's no utility in it, or my law considers that there's too little weight on it.
We've got to be careful to work out what was being decided. In Ainsworth and Stewart, the appeal was dismissed on the basis that the judge, first instance judge, was entitled to reach the conclusion that he had, which in that case was strikeout. That is not the same, is it not, as saying that's the decision he had to reach.
But if, my lady, if I can just take you to actually ground 4 that was argued in Ainsworth, it's on page 116.
Yeah.
Is that there was a fairer course which could have been taken. This is at G.
116. Sorry, I'm.
Page 116 of the bundle. The authorities bundle.
Yes, that was the complaint.
That was one of the grounds that were raised as to the fairness of the
Indeed.
Yes. And that's why the treatment comes in at paragraph 44. Otherwise, that the ground that the fair process, having regard to the wide discretion, is for strikeout, and that there was an entitlement to decide so because of the fairness. And for the reasons that I've set out, fairness here includes all those factors, including the effect on the offer, the disruption to the parties, the cost implications, and why the submission from the appellant, contingent as it is upon Viguzzi, is no longer the correct approach because of the sea change that happened on the 1st of April, and now the requirement to enforce compliance with practice directions, rules and court orders, as well as more of a focus on proportionality and the effect on other court users as well. To the extent that I need to, because the grounds are formulated in such a way that Mrs. Justice Hill's treatment was unorthodox, and to underline the point that I made earlier, if one reads through, what one sees in terms of the structure is that the Court of Appeal in Ainsworth dealt first with the issue of compliance up to paragraph 42, and then from 43 to 44 dealt with the issue of discretion, which underlines the point that I made at the start, that this is not simply a question of one singular aspect of discretion. There were matters in respect of non-compliance with rules and practice directions. And this was one of the criticisms that Mrs. Justice Hill made in terms of paragraphs 15 and 16 of the Deputy Cost Judge's decision and goes back to that 4-1 moment. Again, underlining that this has not been addressed through the lens of the overriding objective.
Are you looking at Mr. Justice Hill's judgment?
Yes, paragraph 133 and 134.
Thank you.
This is the ratio of her decision.
Failure to give sufficient weight is classically a criticism of evaluation rather than of principle, isn't it?
Well, what one has there is that the weight to the requirement to comply with rules and practice directions, but also principally, and this is where the error of principle comes in, because there was a failure to identify that there had been a breach of the practice direction itself.
Where does that failure to identify a breach passage appear, Mrs. Justice Hill? I'm just trying to remind myself.
That comes from that comes from ground 1, and you'll see it's at paragraph 76.
76, thank you.
First, I cannot see that the judge ever specifically held that part point 23 was compliant.
Well, isn't she saying the judge never held that there was Ainsworth compliant? This is rejecting a case brought by the appellant, that somehow the judge is at fault because the points of dispute were not Ainsworth compliant, but the judge held the contrary, and Mrs. Justice Hill is rejecting that argument. And she says at 77, if as appears to be the case, the judge did consider that point 23 was not compliant. So isn't she accepting that the judge did proceed on the basis there was non-Ainsworth compliance in this case?
He proceeded, as one can see, with a focus, and this again is the next sentence in paragraph 76, that the focus was whether there was any curative ability within the amended points of dispute. What he never took into account is that there had in fact been a breach, and the breach in terms is compliance with 8.2 of the practice direction and Ainsworth.
At the moment it rather seems to me that the principal ground of your criticism of the cost judge is not a criticism that Mrs. Justice Hill made or found.
My Lord, I respectfully say something different.
Of course,
which is,
and that's
which is
absolutely permitted. Yeah, like looking at those paragraphs.
So one sees, if one reads up further at paragraph 71, there was an attempt to persuade otherwise that point 23 of the respondent's points of dispute were not compliant. I was right, that were compliant, forgive me, it's expressed in the...
Where are you reading from?
This is from the same page, my lady, up at paragraph 71.
Yes, and Mr. Lyons was certainly attempting to argue that. He's had the wisdom not to pursue that point before us.
But that wisdom, if I may, falls into the decision of the Deputy Cost Judge, because I appreciate there was disagreement between bar and bench on this, but if I perhaps can just press the point a little further as to...
So are you, just to be really clear about your position, you say the Deputy Cost Judge never found non-compliance?
That's the conclusion that Mrs. Justice Hill reaches. I can't see that the judge ever specifically held that they were compliant. And in my submission, one can see that if one goes to goes back to paragraph 15 at page 155. And even if one reads back up to paragraph 13. Because what he talks about thereafter is the ability to have, this is the Deputy Cost Judge.
What page are you at?
This is at 155 and paragraph 15.
Is the did, sorry, because I've underlined myself and I can no longer work out what's original underlining. Is the word did underlined in
Yes.
paragraph 77? It is. Thank you.
And this is the binary question that is answered in O'Sullivan, which I'll cede the floor to Mr Mason on in a moment. But the question of compliance is a binary question. They either are or they are not. I'd hope that's not a proposition that one can push against. But again, once one arrives at that consideration, that then factors in, for the reason I've said, into the exercise of discretion for the non-compliance point. But in order to get there, one needs to make a finding that they are in fact non-compliant. And that's the criticism that Mrs Justice Hill gets to at paragraph 76. And that is a misdirect in and of itself.
Okay, I see the time. How are we doing for time?
If I may, I think it would be useful for you to hear from Mr Mason in respect of O'Sullivan, in respect of the binary question. If the court would find that of some utility, I appreciate it. Maybe that actually that's a point that's accepted. But if it's a question of binary compliance, in my submission, it does need to be taken into account and an express finding.
I'm not saying we won't hear. I'm just looking at the clock and.
It may be another. I appreciate it's now 1:05. Would you prefer to come back at 2 and we finish, and perhaps it'll take another 20 minutes, half an hour, or would you prefer to come back?
I think we'll break now. Come back because we need to allow time for any replies.
All rise available.